So, for the next 15 to 20 minutes, I'm going to present on best practices in IP licensing. This is broadly based on my experiences and my practice over the last 8 to 10 years based on Indian clients. So, some or a lot what I say may or may not be relevant in other countries or other jurisdictions such as US or Europe. Thanks. So, I just wanted to start with the growing importance of IP, particularly in the Indian environment. I still remember about 8 to 10 years back, there was not much importance given to IP in an M&A deal by even large Indian corporations, for example, by startups, by so many other people. Now, I would say Indian companies have really understood the value of IP. They know why it is important to protect IP in the patent space, in the design space, in the copyright or trademark space. I interact with a lot of startups, and most of the startups which I know, they give a lot of value and importance to protecting IP at the very beginning, including their trademarks, brands, and patents and technologies. And this pretty much sums it all. This data is as per 2011, but it says that IP is one of the biggest asset class on the planet and constitutes almost 80 to 90% of all the Fortune 500 companies' assets, intangible assets. In the US alone, it is valued at $5.5 trillion. So that says it all, according to me. These are some of the statistics of recent, this slide and the slides which are going to come next. About the growing importance of IP. Some of the top technology companies in the world, if you see their balance sheets, you'll see intangible assets valued in billions and billions of dollars. You talk about Apple, Microsoft, Google, they're all in tens of billions of dollars, 20 billions of dollars. This statistics, this chart will show from 1980 onwards till 2013, in the last 33 years, you can see there is a huge exponential growth in not just patents, but design rights, patent rights, trademarks. When we started in 1980, there were less than 1.5 million patents, for example. And now the figure is crossed to many, many, many more million patents. Same with trademarks. You see the exponential rise in trademarks in the last, I would say, 3 to 5 years. Designs has a pretty much same story. So you see that over the last 2 or 3 decades, IP has really become really important globally and not just in India. These are some of the statistics which I pulled out from the Controller General of Patents website. Sadly speaking, if you see in India, 1,94,216 trademarks, whereas only 43,000 patents. I'm pretty sure, and this is not the same story in other developed markets. I'm pretty sure that in the next decade or so, the number of patents are going to be significantly higher in India, and they'll try and match up and catch up with the trademarks also. Now, let's spend a little time on why IP is important. A lot of the companies, particularly in India and even globally for that matter, they do not value IP. They do not understand the strategic importance of IP. And a lot of times I've seen in my experience that IP is something which is left for the outside counsels to handle. And whereas IP being of such a strategic importance, there has to be a cohesive way in which you tackle IP. Right, the business folks, the commercial folks, the management, the in-house IP teams, the outside counsels, I think they have to come together and form a cohesive strategy in order to exploit IP and in order to take the organization to the next level. Whereas we see a lot of this missing because there is not a lot of coordination and cohesion between the different arms of the organization and outside counsels which handle IP typically for clients. I would like to spend some time on the corporate, what I call as the corporate governance for IP. IP is something which needs an independent IP policy. Now, you cannot generate IP, you cannot create IP, you cannot protect IP without an organization having a vision to do that. I think at the very basic, I would say that an organization needs to have a vision where they want to go over the next decade or so, and they need to have a proper IP policy to do that. There has to be a culture where the creators of IP, the inventors, the R&D team, they are actually rewarded and they are incentivized for what they are doing. I see a lot of that missing in India up till now. There has to be dedicated funds. How many times have we come across a situation where especially Indian companies, they say that we don't have budget for filing patents, or we do not have budget for protecting trademarks in certain other classes. We would only protect it in core classes. We would only protect certain kind of trademarks. We would not protect copyrights. Or we will not conduct a raid. We will not go for a litigation because it's not important for us. A lot of these decisions, which are, I would say, purely driven by funds or lack of funds, I think that culture has to go, and there has to be a dedicated fund allotment to IP protection and enforcement. I think that is severely lacking even in major corporations in India. Whether a company has employed specialized people to deal with IP. How many times have we seen that a company secretary is doing a lot of trademark work for the corporation? There is no dedicated in-house trademark lawyer or what we call as a brand manager. There are R&D teams, and they look after the patents. But again, there is no in-house patent attorney, for example. So I think the entire culture needs to change. There has to be proper fund allocation. There has to be a vision statement. There has to be dedicated human resources to deal with IP. And the last point, which is whether IP executives are involved in the overall decision-making process. I think that is what I was talking about, cohesion between the management, the commercial team, and the IP team. IP audit, very important. Even the best of the companies do not know whether their technologies are lying idle, whether their patents are lying idle, are they being exploited, are they being licensed? I think that is more so because there is no proper mechanism to conduct a yearly IP audit, whether it is for trademarks, whether it is for intangible assets, software, patents, and the works. So I think it is very important that at least every year there has to be a technical audit and an IP audit of all the IP assets of the company. Also, an IP audit will also give you a fair idea of what are the breadth of your patents, how you're safeguarding against your competitors, and so on and so forth. So I think a lot of these things are not being done in India, and I think that culture needs to come in. Sorry, just moving back, valuation of IP, I think that's another area which is completely lacking. We were just speaking today, the panelists over lunch, and we were saying that a lot of these M&A transactions or asset purchase transactions which we come across in India that are purely determined by commercials and investment bankers without valuing IP. So the deal is valued overall based on the risks and based on the profits and based on the balance sheet of the target. But there is no IP as a standalone asset is never valued. So I think that needs to change. Life cycle of IP, idea to monetization. I think we pretty much know this. Creation, identification, protection. How will you protect IP? Do you enter into non-disclosure agreements with your clients? Do you enter non-disclosure agreements with your suppliers? Do you have offensive and defensive strategies? Is there a risk management? Is there a process flow? A lot of times I've seen that certain basic things like even invention disclosure forms, for example, there is no fixed mechanism within the company to have invention disclosure forms or periodic disclosure of your inventions by the R&D team. So a lot of these things need to be done. Only when you identify and protect IP would you then be able to monetize IP or license IP. These are some of the examples of successful licensing strategies, and we can go over and over. A lot of companies have done this. Qualcomm, for example, earns more than $10.4 billion from licensing its patents relating to 3G mobile technology. So I think the IBMs and the Qualcomms of the world, the technology giants, they have really exploited IP and done really well in terms of IP licensing. I would briefly want to deal with IP licensing and advantages, disadvantages, and this is more from a cross-border IP licensing perspective. Now, when a decision is taken that should I or should I not license IP, I think that is done on a lot of commercial factors, and it depends really on what is the business position of the company vis-a-vis its competitors, and what does it seek to really achieve. So, for example, if you're a global patent holder and if you want to create new revenue streams over your idle patents, obviously licensing them across countries would make a lot of sense. Also, licensing patents would constitute working of a patent under Indian law, and therefore licensing a patent to an Indian company, for example, would make sense because that will constitute working. It will also constitute use of a trademark, which would otherwise not be used in India. And non-use could lead to revocation of the trademark. So there are a lot of advantages of licensing, whereas there are a lot of disadvantages of licensing also. I think that is really a commercial decision which needs to be taken based on various factors. Disadvantages, prominent disadvantages which I could think of would clearly be that that's a limited income which you get from royalties, for example. You have to be really conscious before you decide on which licensee do you want to license your patent or trademark to, because he or the company may not be able to meet your quality standards, and that could lead to reputational issues and reputational problems. Also, arbitration and litigation, that is one aspect which I'll discuss later in my slides. But this is basically, licensing is not something which automatically happens. I think there is a lot of thought process which goes into it. Some of the major considerations, I would say, in drafting an IP license agreement, this is again a cross-border IP license agreement, would be, I think, what is the nature of the IP really which is sought to be licensed? Because different IP would require completely different set of commercial clauses, legal clauses. So, for example, what you're licensing is a software platform, then the license agreement will have to be drafted in a very different way. There will have to be a software services agreement. There will be a licensing of the technology platform. There will have to be, as I said, licensing of the software services itself, because the licensee would not know how to implement your software. If it's a pure know-how and technology, then and therefore it doesn't have any protection in that particular territory, then obviously you'll have to carefully word those clauses. So a lot of it would depend on what is the nature of the IP which is sought to be protected. Also, a lot would depend on valuation and pricing. I think one of the stickiest issue in IP licensing is what happens to improvements and enhancements. So when a licensee improves over your technology or improves over your patents, who gets the ownership right in that improvements? Similarly, monitoring compliance and having a strong audit clause in the license agreement, because it's one thing to say that I've entered into a license agreement, but if you don't periodically audit the kind of revenues you're going to generate and the royalties which are going to be calculated, then there's really no tangible benefit in entering into a license agreement. Typical clauses, I would not want to deal with all the clauses. I think clearly the grant clause is very important. A lot of times we have seen that we are not clear as to whether we are giving an exclusive license or a non-exclusive license. What is the territory of that license? What is the duration of that license? Again, how is the royalty and the consideration worded? Is the royalty on net sales, percentage of net sales? How are the net sales defined? So a lot of it would depend on how you word these clauses. Arbitration, in a lot of these cross-border licenses, I think dispute resolution and arbitration becomes really important. Obviously, both the parties would seek neutrality, and therefore typically we would go to SIAC, which is in Singapore, or the LCI in London. Again, this could be a very costly exercise, and therefore you have to carefully craft your arbitration clause and dispute resolution clause. Also, because of some of the recent Supreme Court judgments on this, you really never know whether the arbitral award, which is going to be rendered by either SIAC or LCI, would it really be enforceable in India? And therefore, do you keep the window open for approaching the local courts for interim injunctions? I think all these things have to be factored in before drafting the arbitration clause. Reps and warranties from a licensee as well as licensor point of view. Obviously, from a licensor point of view, you would want, as far as title and ownership reps, you'll want to keep it at the very minimum. Whereas from a licensee point of view, you want the entire world. Performance guarantees and performance warranties, I think that becomes quite a sticky issue in license agreements. Also bankruptcy. In India, for example, IP as an asset is not, does not have any special recognition under the bankruptcy laws. And therefore, if a licensor turns bankrupt, how do you secure protection over the licensed IP? Nobody knows, and therefore we have to be very careful in drafting the bankruptcy clause also. Some of the problem areas, I would say, I think what I could think of is these are 4 or 5 biggest problem areas in drafting a license agreement. The biggest of them, I would think, and especially in technology and know-how transactions, is how do you segregate pre-existing IP, new IP, and the improvements, and who gets ownership over what? Because in a technology or a know-how and trade secrets, there is very little to differentiate between new IP, improvements, and pre-existing IP, and how would you demonstrate that something was created subsequent to entering the license agreement? And therefore, I think it is critical that we have detailed annexures and schedules to the license agreement which demonstrate what was the pre-existing IP, and therefore what was the improvement over the pre-existing IP. Similarly, certain legal areas like concept of licensee estoppel. In J.K. Jain and others versus Ziff Davis, for example, it's a trademark case where it was held that licensee estoppel is not fine. However, in Enercon, for example, it was said that under the patent regime, for example, it is perfectly valid to challenge the license or patent. And therefore, different treatment for trademarks, different treatment for patents in India. This is again a very tricky clause. Recently, in the last 2 or 3 years, we have seen a lot of interplay between competition antitrust laws versus IP laws. And therefore, if the licensor has a dominant market share, how would you draft a clause so that there are no antitrust ramifications? Any kind of exclusivity does not result in any antitrust domination. So product liability is another sticking area, because if you're talking about a franchisee or a trademark license agreement, I think the reputational loss is huge if proper product standards are not maintained. And also another area is, would you be liable under product liability laws of that particular jurisdiction if the licensee fails to comply with certain regulations? And therefore, sufficient safeguards have to be built in the license agreement to ensure that this does not happen. I think these are some of the thoughts which I had, and these are some of the issues which I wanted to discuss. That's about it.